Now this right here is how bond violations usually surface, not through paperwork, but through real-world evidence. And when the prosecution walks into court with a video instead of just an allegation, that instantly raises the stakes.
I do want to make a record very briefly. I do want to make it clear to the court that the complainant in this matter did show me a video today, and I did show defense counsel. It does show what people would consider to be a bond violation. It shows the defendant going outside of the complainant's car and going up to her window and saying some things. She advised that he was following her while she was in her car. And
is she here?
She is, Your Honor.
Ms. Poquich, you see this video?
I sure have, Judge.
Okay, yeah, that's a problem.
I would agree, but I'll make my record if the court wants to hear from the people first, and then.
Yeah, well, yeah, you guys can have a seat. All right, you want to call your witness up?
I will, Your Honor. I will call Kenya Jennings. Would you like me to put her on the witness stand?
No, she's okay right here. Ms. Jennings, can you come stand right here at this witness stand? At this podium? Oh, right here, right at the podium here. All right, just make eye contact with me, okay? Can you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Okay. And you got to speak loud and clear for my court recorder, okay? Ma'am, are you alleging that Juan Gibson had some contact with you recently?
Yes.
Do you recall about when that contact was?
February 11th.
February 11th? Okay, and he was arraigned on January 20th of 20.
Notice the timeline here. He was arraigned on January 20th, and this alleged contact happens less than a month later. In the court's eyes, that's not confusion, that's fresh defiance.
26, what was the nature of that contact?
Well, he followed me to pick up our daughter, but.
Did you know he was doing that?
No.
I mean, did he call you and say, hey, I need to follow you somewhere? No? How did you know he was following you?
Because I was sitting in the car at the light and he was honking the horn like excessively, and I looked to the side and it's him.
Okay. And then did you get to the location you needed to be at?
Yeah.
And that was a school?
In my daughter's school. I didn't let him get to that point. I didn't want him to get to her school, so that's when I started recording, hoping that he did get that far to her school.
Okay. And so you made a video of this?
Yeah.
And did he approach your vehicle?
Yes.
And what happened then?
I guess he was just saying how he wanted to see our daughter and other things, but I'm not sure.
Your two attorneys want to approach with the video? I want to see the video.
Yes.
Do you have?
You have it in here?
She has it on her phone.
Don't look at her.
I did have the email to the detective, but for right now.
Don't look at her.
But for right now, we can get it from her phone. Go ahead.
Yeah, you can grab your phone, ma'am, or if someone can hand her phone up. And if you could just get that video up and then the attorneys can approach with it.
Your Honor,
I'm good, please skip forward.
I'm going to skip forward because a portion of it didn't have anything. Yep. That's it.
Is there a parenting time order in place? Do either of the parties know?
I don't believe there.
This is where things get legally messy. There's no parenting order in place, which means both parents technically have rights, but a no-contact order overrides that. So now the defendant is caught between parental access and criminal compliance. And guess which one the court prioritizes?
It's Judge.
All right, well, if someone wants to see a minor child, that's certainly not the way to do it when there's a no contact order. I arraigned this case. So, Ms. Pope, do you have any questions for the witness or anything you'd like to put on record?
Can I just make a brief,
Please.
Okay, Judge, I think the court hit it up in the nail on the head. There is no parenting order in place. There is no family court case. Currently, both parents have legal custody over their child, their 3-year-old child. So what I
How
would,
so? Is he on the birth certificate?
yeah, he's their father.
Okay.
The child's father.
She has my last name, Your Honor.
So what's happening, at least in my understanding, is by virtue of this no contact order, the complaining witness in this case is effectively preventing him from seeing his child. I understand that arrangements can be made via third party. Mr. Gibson's sister was that third party at some point, but for whatever reason, their contact fell out. I would also note, it's my understanding that the complaining witness did contact Mr. Gibson concerning care about their child. Again, Mr. Gibson understands this is a one-way street, right? He's the only one with an
And Mr. Gibson was advised. I have a long slew I put on an arraignment. And one of the things I tell him is, if she contacts you, do not respond. Call your lawyer. So he knew that.
I would just ask the court to reiterate that to him. I believe he understands. There's no allegations of assaultive contact. The court can see from the video, it really was a concern for his child. Is it technically a violation of the bond order? Yes. And did the court instruct?
And here's the defense strategy: context over conduct. They're not denying the violation. They're saying the reason matters. But legally speaking, intent to see your child doesn't cancel out violating a direct court order.
Him otherwise? Yes. I'm asking this court to give him one more chance in light of the fact that, again, the conduct concerns their daughter, and quite frankly, this matter belongs in family court.
Your Honor, if I may, I understand that they have a child in common, but this behavior is concerning given that given this court order. The child was not present at the time. He was deliberately following her in her vehicle and came out while she was at a red light. And she advised me that he kept doing this at every red light.
Here's the problem. You don't have to say anymore. Here's the problem, Ms. Polkowitz. I think I'm a pretty reasonable judge. I don't try and nail people. I dismiss the cases when the prosecutor's not ready to proceed. I am certainly not slanted towards one side or another. But I'll tell you this, when I tell someone with an assaultive case, I go over a whole thing, and I know I write them because it's my handwriting, so I know I said it. I tell them, you can't call her, you can't write her, you can't email her, you can't go to where she lives, works, or goes to school. If you see her in public, you must turn around and leave immediately. No contact means no contact. If you violate my no contact order, you will go to Wayne County Jail. That's what I say. So when someone hears that and they decide, and this isn't just a deed.
Listen closely, this is the judge reminding everyone that no contact orders aren't suggestions, they're conditions of freedom. Violate one, and you risk losing that freedom entirely. And in a 10-year felony case? That's playing with fire.
It's a assault with intent to commit great bodily harm. It's a 10-year felony. It's a 10-year felony. And if I was a defendant in a 10-year felony and a judge said, if you violate this one thing you're not allowed to do, I'm putting you in jail, I wouldn't violate it. And he did it. Not only do it, it's on video. There's no question he did it. So his bond's revoked.
Judge, would the court consider a personal bond with GPS tether? I don't believe that that's conditional.
No.
And there it is, bond revoked. No trial yet, no conviction yet, but custody begins now. So let me ask you, should someone lose their freedom before trial for trying to see their child, or does breaking a court order cross a line that the system can't ignore?
I will not.
And I also may note his guidelines would call for 0 to 17 months and for 11 months, which means he's looking at probation. So locking him up pre-trial isn't even what he would face.
He's a danger. He doesn't listen to court orders.
No, hang on.
You don't want to talk.
Judge, this is not the first time that somebody has violated a bond condition. It happens. I understand that the court it speaks through its orders and that there is an alleged violation. But what I'm asking for is not to lock him up. He is a working man. And again, I think the circumstances of this matter, it's not as though he's harassing her and continuing to contact her or sending any threatening messages. The context matters because he was trying to see his child. And so I'm asking the court to consider a GPS tether instead of revoking his bond and putting him in the Wayne County Jail, because that is ramping up a condition of bond and that will further ensure the safety of the community.
$25,000, 10% with the GPS tether. You're welcome.
Under only.
No contact means no contact. Talk to her. She's here to protect you, I'm not. I'm done talking to you, sir. That's your bond, he's going into custody.